Also, it should be clarified why UK does not fulfill international agreements. Therefore, I would like to quote a statement from the Legal Department of the EU Commission. I quote, "If there is evidence in breach of European Union law, this Commission should open infringement proceedings against the Member State to the EU Court of Justice."
Mrs. Serdinska, from...
Thank you very much. Thank you very much, Chair. The case of Mr. Zinser is known to the Commission, as he wrote several times, submitting some of the documents. I refer now back to the letters sent to Mr. Zinser in the past, responding to his claims. However, I will limit myself to the assessment or the reference made to Brussels IIb's regulation, which is Union's law. The Commission cannot assess or take any position on the spendings or financial matters that the petitioner is relating to. It's a question outside the scope of the regulation. Now, turning to the details of the case, or to the details of the claim, indeed, access rights and custody rights fall under Brussels IIb's regulation in cross-border context. However, this regulation is to set the jurisdiction rules, recognition and enforcement of such a judgment. This has been said, it means, or in particular, it means that under this regulation you will find the court responsible to hear the case, and there are rules to facilitate recognition and enforcement. And further, for the enforcement procedure itself, this regulation provides or refers to the national law. So the enforcement itself of any access rights judgment brought from the other member state will be enforced in line with the national law. In the case referred here, it will be under the English law. So in the past, we as said, the petitioner contacted us, and we explained basically the rules of Brussels IIb's regulation. We of course regret very much to hear the difficulties that the petitioner is facing when trying to enforce the access rights order he had from Malta. But as said, we took also, we were provided with a British judgment or English judgment in which it has been stated that the petitioner had not issued an application with regard to how he would like to enforce the order of the Maltese courts through committal or any other proceedings. So this brought us, so to say, or gave us indication that the matter is around the enforcement of this order in line with the national UK procedure. And therefore we do not, so to say, see much possibilities of assessing if there were any, let me say, mistakes in this procedure or something went wrong. It's just impossible for the Commission to assess the national procedure. This would be basically all from our side. Thank you.
Mr. Wieland.
Thank you. Just continuing the question of Mr. Wieland, I would like to ask the Commission to answer which concrete steps did you undertake concerning to that petition, because as far as I understand, you have restricted yourself with the contacts with the petitioner. But what about authorities? So maybe you can provide us with the answer. The second one, Commission is also, as far as I understand, your task has to propose new legislation, and whether you have driven out some conclusions from existence of these cross-border cases which we are looking today. Yeah, which steps in new EU legislation are you ready to propose to resolve this this conflict of national regulations and the national legislation when it concerns cross-border cases, when, as far as we understand, is just the problem we are raising today.
Thank you. In the case referred to, we have been only in contact with Mr. Zinzer. We asked him to submit the relevant documentation, and in particular the judgments issued by the courts, the Maltese and the British courts in this case. Briefly to the second question you asked about what about new legislation, I would like to inform that Brussels IIb's regulation will be reviewed shortly. We are of course aware of the problems of enforcement itself, in particular in the family law area, and it's not only let me say the British system, and as we face, so to say, similar claims from any other EU country. So it would look to us that, or it would seem to us that the enforcement procedure deserves, so to say, further looking into this, so to make available for citizens to, so to say, to getting the final result, and not only, so to say, a middle-term result, just to direct to the court and say, so to say, you go there. We understand that, of course, the citizen will only be benefiting from the EU rules if he will, so to say, have the final results in terms of enforced judgment. The Commission is now undertaking the evaluation of the regulation. It will publish soon an application report where we also refer to the problems with enforcement in family matters, in parental responsibility matters. And as a next step, it will also assess the necessity of undertaking any or proposing any amendments to this instrument, with the view also of making the enforcement under this regulation effective. Thank you.
Ich will nur kurz sagen, das ist genau die Antwort, die die Kommission jetzt in der zweiten Runde gegeben hat, ist das, was man eigentlich erwartet. Die Aufgabe der Kommission ist doch nicht, Brieffreundschaften mit Petenten anzufangen, sondern die Kommission hat die Aufgabe, Hüterin der Verträge zu sein. Und wenn man sagt, das verstößt gegen den Geist dessen, was wir haben, dann muss zumindest doch einmal kritische Nachfragen, müssen doch mal kritische Nachfragen beim jeweiligen Mitgliedsland erfolgen, wie denn die Handhabung ist. Das ist ja auch nur bedingt eine Frage, wie ein Gericht entscheidet, sondern wie ich zwischen zwei Gerichtsentscheidungen, Malta und England, wie ich mit der Sache umgehe, wie proaktiv. Der Petent hat hier Geld ausgegeben in einer Größenordnung, wo die Kommission in anderen Fällen Strafen gegen Firmen und Multis und Staaten verhängt. Das hat der Petent bisher ausgegeben, nur um festzustellen, dass das, was die einschlägigen Brüsseler Abkommen wollen, nicht erreicht worden ist. Und excuse me, Chair, I would have expected that the Commission gives another short response what they are going to do now. I mean, we saw the case, we complained, and there is no second reply from the Commission. I want to have something like a promise what the Commission now is intended to do.
All right, yeah. I will ask for you. So, what is the Commission going to do immediately?
Well, immediately, I hope you don't expect me to go to UK on my own, but we will need to look at the case, of course, once more and see if indeed to help the citizen who did not, so to say, could not successfully enforce this, to see if from the Commission side any authorities, a part of the courts, can be contacted to see maybe social services who are involved in the enforcement procedure. To see if they could provide more information why in this, so to say, long term it was not possible to enforce this decision. So we are, of course, we are happy to look again at this case, and we were also informing Mr. Zinzer that if there are any additional information which would help assess, so to say, if there was an infringement of EU rules, we would be happy to look at the case again. This goes without saying. For this petition and any other petition in these matters.
No, this is not very satisfactory, but anyway, Mr. Hitul, Mrs. Bogert.
First of all, as a mother, I would like to express my sympathy for the suffering of the petitioners. Now, I understand that what those two petitions have in common is that the petitioners expressed their concern about the functioning of the UK Child Welfare Services and the UK local authority. My task here is to assess whether there is a legal basis under EU law for the Commission to intervene. The legal basis which were brought up by the two petitioners orally now in the intervention, which I hadn't seen in writing, were the UK Human Rights Act, which is UK national law, the Rome Statute, which is the International Criminal Court Statute, so that is not EU law either, and the European Convention of Human Rights, which is the Council of Europe Convention. Now, when it comes to possibly applicable EU law, in writing it was submitted that there might be a violation of Article 3 of the Racial Equality Directive and Articles 10, 22, 24 and 33 of the Charter. When it comes to the applicability of the Racial Equality Directive, the Commission would like to stress that acts of a public authority, such as taking a child into long-term care or giving a child free for adoption, are not a service in the sense of the directive. Nor do they fall under social protection, because the term social protection under the Racial Equality Directive is to be understood as covering social security and healthcare, but not the functioning of social welfare services. Then, when it comes to the question whether there was discrimination on the basis of racial or ethnic origin, this is apparently also not the case in two cases at stake, so from this we can conclude that the Racial Equality Directive does not apply. Why? Because the Racial Equality Directive only applies if there is discrimination on grounds of ethnic or racial origin, not nationality. Then, whereas to the applicability of the Charter of Fundamental Rights, I would like to explain that the Charter only applies to, it doesn't apply to every situation of alleged violation of fundamental rights. The Charter of Fundamental Rights, according to its Article 51, only applies when the member states are implementing EU law. So the Commission can only intervene in these kind of cases if it is proven that there is an implementation of union law. When it comes to the question whether in these particular cases the UK Child Welfare Services or the local authorities have implemented EU law, this has to be answered in a negative. This is only an implementation of national UK law. This does not mean, however, that there is a lacuna when it comes to fundamental rights protection in the UK. In such cases, it is for the member states, so the UK, and its judicial authorities to ensure that fundamental rights and human rights are effectively respected and protected. So what the petitioner can do is to seek redress at the national level through the competent authorities or through an ombudsman or through the courts. Then after the exhaustion of domestic remedies, there is a possibility to lodge a complaint with the European Court of Human Rights, as the European Convention of Human Rights does not have this precondition of applicability of EU law, but the Charter has, as I just explained. Then, in general, regarding the functioning of child welfare services and child protection services in the different member states, the Commission is currently drafting guidelines to support the member states in strengthening and improving their child protection systems. The objective of these guidelines is to find ways to promote and support an integrated approach and facilitate cooperation and coordination among all agencies involved in child protection issues. These guidelines are expected to be adopted by autumn 2014. And in parallel to the preparation of these guidelines, the Fundamental Rights Agency of the EU is also carrying out a mapping of child protection systems in the different member states. This mapping should be completed by June 2014. But as there is no legal basis under EU law in these cases, the Commission, apart from issuing these guidelines, cannot further intervene.
Thank you. That was clearer than before, but there's something we can do next. Mr.
Basic propaganda, but something positive, to make people aware what is the institution and what is the child, what is the mother, and so on. Because there are some they are not meeting. Everybody goes by his own line. Who is more power, he decides. And the welfare of child is completely lost. This is my attitude. Thank you very much.
Here, Commission as a legislator, I guess, is failing on interpretation of existing European law, not speaking about amending it. We discuss.
Eben gerade, weil es nicht um das Recht der Eltern geht. Es geht um das Recht der Kinder. Es geht um das Recht der Kinder. Und ich kenne auch...
De Luca would like to say a few words. From the Commission. Mrs.
Yes, thank you, Chair. We have heard all these cases relating forced adoption in the UK. I must say that the Commission is fully aware of the problem because we have received several complaints about the rate of domestic adoption in the UK and also carried out without the consent of the parents. And I would like to point out that not only foreigners, but also British people claim to be victims of forced adoption in the UK. Indeed, the complaints which were received directly by the Commission came all from British people, for instance, from grandparents of children who has been put up to adoption without the consent of the mother. Normally a single mother also. Indeed, there was already a study of the European Parliament dated from 2009 which identified the high rate of domestic adoption in the UK compared to the other member states. And a majority of these adoptions are carried out without the consent of the birth parents. So the problem is well known. What the Commission can do, not much, because you know that the issue of adoption is not currently regulated at the EU level. International adoption is regulated by an international convention, the 1993 Hague Convention on Inter-Country Adoption, of which all member states are party, while domestic adoption, national adoption, are in the remit of the member states. So it means that member states can regulate as they want the issue of adoption. The Commission until now has suggested to these parents to exploit all possible remedies at national level and in the last instance to address the European Court of Human Rights. Because for the breach of the respect of family life. What I can maybe the Commission as guardian of the treaty cannot do much more in this situation, and I want to inform you that a possible legislation at the EU level on adoption can only address cross-border cases. So cases like this one related to forced adoption in the UK would not be in the scope of this possible regulation. And in any case, as it is regards family law, we would need the unanimity of all member states to have a EU regulation on adoption, which is not the case, I can assure you. Only things that I may suggest to this committee, because we have cases like the Danish cases, the cases of the Jugendamt in Germany, where this committee organized a fact-finding mission in order to really understand why the situation is like this. Maybe this could be a solution, a fact-finding mission of this committee. But from the part of the Commission, I'm afraid that we can do much more on this issue. Thank you.
Doesn't sound very optimistic, but Mr. Kasbeb. Now the Commission, please, Mrs. Villar-Badia. Please be quick.
Yes, thank you, Madam Chair, and thank you to the petitioner for this thorough presentation. Well, first of all, let me say that we are very sorry about all the difficulties that you've gone through in your abduction processes and in the current situation in which your child is in France. Sorry. Yeah, sorry. So, well, we understand the frustration of many parents here that have been presenting their cases, and let me assure you that the Commission would be very happy to be able to have more powerful instruments to be able to act against what is perceived as injustice in situations in many cases. Unfortunately, the Commission can only do what it can do, which is basically to ensure that what is already in force now is properly applied. And sometimes, unfortunately, what we would all desire to have already as existing law is still not existent. And that is because, as one of my colleagues said, sometimes member states do not have similar positions and cannot reach consensuated decisions as to what legislation to want to adopt in this very sensitive issue of family law, where each member state has its own social, cultural, traditional, religious background and beliefs. So it's not to justify the Commission, but to explain you that we often are confronted with situations in which we feel frustrated because we cannot do more. And indeed, our job is to propose new legislation, and we do as much as we can. Of course, sometimes we do not propose legislation if we see that it's going to end nowhere. And as my colleague also said, for the time being, for example, it's just an example in the field of adoption, we know there would be no consensus in adopting common laws on adoption, so there is no point for the Commission wasting time of MEPs and of its own resources in putting forward legislation that will never make it at Council level. Well, all this having been said, we understand that in the case that has just been presented, there was indeed a decision by Hungarian courts stating that there had been a case of abduction. Now, this obviously is based on the current Hague provisions as they stand, which the petitioner doesn't believe are fair or logical or reasonable in all situations. Unfortunately, the Commission is not the body to judge whether the Hague Convention provisions are adequate. The Commission can only ensure that its own regulation, the Brussels II regulation, which complements a convention which has been adopted by member states at international level, is applied correctly. So it is good to hear the views of citizens and petitioners, but unfortunately there's so much that we can do anyway. So there was, on the basis of current provisions in the Hague Convention, 3 levels, if I understand correctly, of Hungarian courts considered, having heard the petitioner, that there was a case of abduction. Subsequently, the European Court of Human Rights in Strasbourg considered that, in fact, the return of the child back to France was done in too long a time, so that there were unjustified delays. And so it seems that both the Hungarian courts and the European Court of Human Rights did not question the fact that there may have been an abduction. The Commission cannot substitute itself for the national courts, whether it's Hungarian or any other national courts, and we cannot judge specific cases and say in this case where that there's been violence, if that can be proved, this cannot be considered abduction. I mean, we have no power to do that. So national courts, which within even one same member state may have different opinions, in these 3 instances, district, regional and Supreme Court in Hungary, it was considered that there was a case of abduction under the Hague Convention as it currently stands. So we unfortunately cannot do much about it. This case it didn't come down to the Brussels II regulation. It didn't need to be applied in the case of the abduction. Now, we are very sorry to hear that you're having traveling, seeing your child, which is...
Could you please come with a suggestion rather than... sorry, I'm so sorry. You have explained our disabilities very well, but solutions we need.
Right.
Not excuses.
Yes, we understand your frustration, but please try to understand who is the Commission. No, I understand, but I mean, the Hague Convention is an international instrument adopted by member states.
Let's try to do how we can deal with the Commission, the Council, and the European Parliament.
Right.
The excuses we can all give. Okay? Thank you so much.
Okay.
Mrs. Gont.
I'm not trying to give excuses.
No, it's not personal.
No.
Please do not accept it as such.
No, I don't take it personally.
Mrs. Gont.
I'm just trying to say that...
Briefly, Madam Chair. Colleagues, do you remember recently we have discussed about Drosophila melanogaster? And we've been told by the European Commission, yes, there are rules how this little insect can cross the borders, what are the obstacles, what are the checks in the airports, and so on and so forth. Drosophila melanogaster, it is a part of the EU rules and regulations, but the kids are not. We are told now again and again by the European Commission, okay, it's nice, it's dramatic, it's painful, do exist, but yet we have no powers. I see no will and wish from the Commission side, at least, to build up guidelines for the behavior of the member states, our member states, when involving EU citizens belonging to different member states. When involving kids with one parent with one citizenship, another with another citizenship. How to address at least this issue. No idea to start working on that. No idea of collecting opinion and information from member states what to do, because it's so easy and so convenient to say, sorry, we can do nothing. But to see, yes, we can do something, A, B, N elements, because the Parliament, I'm sure, the Parliament will be willing to work with the Commission to regulate on the problem of the children, as in the case of Drosophila melanogaster. The comparison is maybe not fair, but this shows the huge gap in perception and in action from the European Commission side. We can design the carrots, we can design everything else, but not such a dramatic problem which involved human beings. And this is unacceptable. European Commission, you cannot continue in this way to say, sorry, our hands are locked, we can do nothing. Please start doing something and the Parliament will be on your side. But stop complaining about your powerless, because if your power is indeed insufficient or is not existing, it's better to build up another system, because now in May, the European citizens in our member states, including the mother and the father, which are depossessed, will question us, you the MEP, what you can do for my tragedy. And I will tell, sorry, the European Union is beautiful, it's a masterpiece, but when it's about your kid, which was taken away by abusive, discretionary authorities, we do nothing. If it's so, we have to change the rules for the European Commission. Stop. Thank you.
Mein Vorredner Victor Postonaro ein bisschen ins Positive übersetzen. Also wir müssen ja auch anerkennen, die andere Seite der Medaille ist ja, gerade wenn es um Rechte der Kinder geht, wenn es um Adoptionsrechte geht, wenn es um Scheidungsrecht geht, verteidigen ja die Mitgliedstaaten ihr eigenes Recht, also mit allen Mitteln. Also die Mitgliedstaaten fühlen sich ja verantwortlich und sagen ganz trocken, das geht erstmal Brüssel überhaupt nichts an. Das heißt, ich möchte die Kommission quasi auffordern, Sie haben uns hier als Verbündete, weil das Defizit erkennen wir ja alle. Also wir haben schon genug Fact-Finding Mission gemacht. Wir waren in Dänemark, wir waren in Spanien, wir waren in Deutschland. Und immer landet die Debatte an der Stelle, wo die Mitgliedstaaten sagen, das ist unsere eigene Verantwortlichkeit. Schönen Dank, dass ihr gekommen seid, liebe Abgeordnete aus dem Europäischen Parlament. Aber für die Geschichten sind wir zuständig. Die glauben das nicht nur, die setzen das auch mit allen Mitteln durch. Da gibt es einen riesen Widerspruch. Und ich sage es noch einmal, auch an die Adresse der Kommission, betrachten Sie uns hier als Verbündete, dass wir hier versuchen müssen, die Rechte der Kinder europäisch zu etablieren. Weil wir merken, dass ja so kann es nicht weitergehen.
Yes, thank you, Mr. Chair. Mrs. Chair, of course, I think we are all equally touched by these very disturbing images, but I can only say I'm very sorry to tell to the petitioner's son that he is so disappointed with the Commission's reaction, because essentially I can only repeat what has been said before. The task is to examine whether there has been a breach of EU law in the case of the petitioner, and here, in cases of child custody, there is no basis in EU law to consider whether the Charter of Fundamental Rights, which prohibits discrimination, would also require that it concerns a case of implementation of EU law, which is not the case here. Granting of custody rights, arrangements for their exercise, and the role of the social and child protection authorities is simply not a question for EU law. And discrimination on the basis of nationality is only prohibited when it falls in the scope of EU law. For these reasons, I can only repeat what the petitioner's son did not like to hear, that the Commission cannot follow up on this. Thank you.
Thank you. It's obvious that we have a gap in legislation that has to be filled the quickest possible. Mrs. Danoga.
Yes, Antonova and Ilya Antonov of Latvian citizen Laila Brice, we have in Latvian press now the information that it's dangerous to go to another member state for work because your child can be kidnapped. And that is the breach of, and I repeat what my colleague Kinga Gerns told, that we just can to refer to this principle which is breaking. We don't need only to speak on child adoption legislation, but on right for free movement of workers. Because these workers, they have families, they have children, and they are afraid to execute this right. And continuing the second, my second point, I try to be brief, is the behavior of Commission. You see, we see now so many officials representing Commission. You are full-day working officials there, and you do not want even to contact properly the member states. In the case of Antonova, I refer to the case of Antonova because we are seeing, examining this case for second time in 1 year distance. The first examination of that case was in February last year. And during that time, Commission did not manage even properly to ask from Member States for proper answer. Only one letter was sent to the Dutch government, and the response was just neglecting the European Union as such, and the Commission and our committee. Because the Dutch Minister for Justice just wrote, no, it was not only the reason why children were withdrawn from the family that they speak their mother tongue within the family, but there were another reasons, so there is no breach of international law, it's our interior Dutch matter. And Commission officials, you did not even manage to send another letter to the very same official to say by saying that your answer is not proper. You please answer us just deeply concerning the case, not like this. Yeah, and we even do not have now in the dossier the proper answer from Dutch authorities by having so long court cases, by having some decisions in favor of mother. No proper answer, and we have now here also a lawyer who is watching the case, but unfortunately Dutch authorities are completely neglecting us, and we smile and we do nothing. That's awful. Yeah, and I want, of course, support the idea to make a fact-finding mission to Britain, because we have a lot of British cases, but this is a matter of all member states. Yes, mostly with migrant workers from Eastern Europe settling in Western Europe. And that's a very dangerous tendency with kidnapping of children. We have to tackle using all instruments we have.
Mrs. Danoga, the Commission, do you have anything to add relating to the items we've been discussing up to now? If you wish to, to intervene, yes.
If I may, you asked to come up with suggestions. Well, we had our Commissioner, Vice President Reding, suggesting to abolish Article 51 of the Charter, which limits the field of application of the Charter only to when EU law is applicable, to have a general basis for the EU to act in the field of fundamental rights. I suggest that we will all lobby to abolish Article 51 of the Charter, so finally the EU can also act in the field of fundamental rights. And we would like the support of the Parliament for that. Thank you.
Yeah, thank you, Madam Chair. Yeah. When I was trying to respond to the petitioner, I meant to say also that, in fact, the Hague Conference has set up a working group to study the relationship between violence cases and abduction, perhaps to tackle situations like the one described by Mrs. Orosz. So that on the one hand, then also we've been accused, although the MEP is not here now, that we don't do anything. Well, we do what we can, and as much as we can. For example, there's this judicial network, European judicial network in civil matters, where member state representatives meet and discuss, for example, abduction cases and custody cases, and where difficulties that arise in particular cases are discussed bilaterally. And one of the topics that we intend, we've discussed this internally, and we would like to see a bit more in depth how we can help in all these matters that involve the social authorities. When access rights are granted to a parent, but the way in these access rights are granted, so that perhaps we can see whether there can be some common approach adopted by member states authorities as to how these access rights should be granted, even if they have to be in the presence of a representative of the child welfare authorities.
Thank you.
Yeah, and also just to finalize, also the MEP, I don't know the names, unfortunately, I cannot see the names, the gentleman that left. I would like to thank him for his intervention, because he did recall that, in fact, unfortunately, the law is at the moment what it is, and we cannot take it on our hands. So if there's a convention that has been agreed at international level by several countries, we cannot, even if we think morally and ethically that we are justified to take our child away because we have a case of violence. Unfortunately, if we do that, then we are faced with abduction proceedings. So it is perhaps best to check with some expert before we act as we think things should be done, because sometimes the laws do not agree with what we think. So it's best to avoid.
Thank you so much. Thank you. Now, I would very much like to thank the petitioners for their presence here, the members that participated in this discussion, the representatives of the Commission who somehow told about their difficulties in approaching gaps in legislation. In conclusion, the coordinators will prepare, in other cases, in the letter to Mrs. Reding, the Commissioner, not only the British cases will be highlighted, but a pressure to the Commission to rethink the ways in which such difficult issues as those discussed today are going to be solved immediately or very quickly. Otherwise, the European idea is endangered. So I give the chair to my colleague here, and thank you for coming.